This is Barry Zalma speaking for Claim School Incorporated, and today I'd like to speak about the need to explain the reasonable conduct of an insurer when dealing with a claim seeking damages for the tort of bad faith, and how courts must deal with defenses to the tort of bad faith. So when a court found that an insured's claim was debatable, the bad faith claim must fail. Bad faith claims are insufficient as a matter of law, where the status of Kentucky law, at least, on the issue was fairly debatable. This was stated in Willowbrook v. Maryland Casualty, a 2018 decision of the U.S. District Court. The courts, legislatures, and the insurance departments of the various states must recognize that an insurer with the best of all possible fraud investigation units will, on occasion, err. A company with a highly trained and motivated fraud investigation unit made up of professional investigators and attorneys who are human will err on occasion. The public and those who serve on juries must understand that an aggressive fraud investigation, even if it reaches an incorrect result, is not malicious, and if negligent, not an act of bad faith. Today, if a jury believes the insurer was wrong in its decision, it must award punitive damages regardless of the instructions read to it by the judge about the elements of the tort. Because of bad publicity created by the policyholders' bar and the press reports of massive bad faith judgments, insurers are not liked by a majority of the people who serve on juries. The prudent defense lawyer will assume that at least 3 of the jurors will vote for the policyholder, regardless of the evidence presented, and defense counsel must win over the remaining 9. The bad publicity that was given to insurers by early bad faith cases has poisoned the public image of insurers. The plaintiff insured only needs to convince 6 of the jurors who may sit in judgment about an anti-insurer prejudice to receive a majority verdict with 9 votes. As a business necessity, insurers must have the confidence of the public that they are financially sound, secure, and have an overabundance of funds available to pay claims. The need to show the security of the company to the public has the effect of convincing juries that a multi-million-dollar verdict against the insurer will not hurt it. Plaintiffs' lawyers disingenuously tell juries they don't want to harm the insurance company. All they want to do is get its attention. They argue that a $10 million verdict might cause an itch in the corporate pocketbook sufficient to cause management to scratch away the need to improperly reject claims. The argument is hard for a jury of working people to withstand. In my opinion, the tort of bad faith has served its purpose. The tort of bad faith and the punitive damages that seem to go with it have, in my opinion, served their purpose. Insurers now have professional claims departments. Insureds are almost universally treated with courtesy and respect. More than 90% of all claims are resolved without litigation or argument. Legitimate claims are paid with alacrity. Insurance fraud, of course, continues to grow. The amount of money taken from insurers every year in the tens or hundreds of billions of dollars. The fear of punitive damages has made the fight against fraud difficult and almost impossible. Even when an insured is arrested, tried, and convicted of the crime of insurance fraud or attempted insurance fraud, attempts will still be made to sue the insurer for the tort of bad faith. Before I retired from the practice of law, I contended daily with insurers who wanted to fight fraud. but who found they must decide to pay a claim rather than face the exposure of a punitive damages judgment. Sometimes the settlement of bad faith lawsuits where there has been no bad faith and an appropriate denial of a claim or refusal to pay a policy limits demand, the insurer concludes it must pay more to avoid a potential runaway jury. I can, as my mentors taught me 55 years ago, state with confidence the opinion that an insurer should spend millions of dollars for the defense of a non-covered or fraudulent claim and not pay a dime of tribute to an insured who brings a spurious bad faith lawsuit. However, practical insurance professionals have a need to resolve litigation as inexpensively as possible to protect the shareholders who want the insurer to make a profit. As a result, the insurer will disobey the millions for defense covenant and will make a business decision to pay the non-covered loss or the fraud, rather than take a chance on an adverse verdict. As with all things in insurance, the attitudes of insurers move in cycles. More often than not, I am now called upon to testify as an expert in bad faith cases that the insurer insists on taking to trial by jury rather than pay off a scofflaw. I can only hope that the cycle continues and more attempts at fraud are defeated. Of course, I am also called upon to testify on behalf of policyholders where the insurer failed to act fairly and in good faith, and those cases seem to be growing logarithmically. The United States Constitution's 14th Amendment also applies to insurance companies, because insurance companies are understood to be persons who operate in the United States and are entitled to all the rights, benefits, and protections of the U.S. Constitution. The 14th Amendment provides in clear and unambiguous language, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Close quote. If the law allows an insured to sue for tort damages as a result of a breach of the covenant of good faith and fair dealing, equal protection should allow an insurer to sue the insured for tort damages as a result of the breach of the same covenant. Some litigants cannot, under our system of constitutional law, be more equal than others. Yet until a court agrees, insureds are more equal than their insurer, because no court has allowed to date a bad faith case, a bad faith tort case, to be brought by an insurer against an insured, regardless of how egregious the conduct of the insured was. Although the courts may think so, the insured's breach of the covenant of good faith and fair dealing is also separately actionable as a contract claim, and that some form of misconduct by an insured will avoid coverage under the insurance policy. Consider Imperial Casualty and Indemnity versus Sagamonian, a 1988 decision of the California Court of Appeal. The court in Agricultural Insurance versus Superior Court, a 1999 decision of the California Court of Appeal, believed that contract remedies adequately serve to protect an insurer from the insured's misconduct without creating the logical inconsistencies and troublesome complexities of a defense of comparative bad faith. In so doing, the California Court of Appeal ignored the logical inconsistencies and troublesome complexities of the tort of bad faith. What is good for the insured should be good for the insurer, and upheld the insured's demur to the reverse bad faith tort theories, and the trial court sustained it without leave to amend. The Court of Appeal, explaining its decision, stated an insurer has no claim against its insured in tort for breach of the covenant of good faith and fair dealing. A breach of this covenant is at base a breach of contract. A relationship including specialized circumstances of reliance and dependence is necessary to transmute such a contractual breach into a tort. Close quote. In the only reported decision in which the Alabama Supreme Court had an opportunity to address this defense, it punted in White v. State Farm, a 2006 decision. Indeed, two federal courts presented with a similar argument have refused to recognize such a defense under Alabama law. In Kransco v. American Empire Surplus Lines Insurance Company, a 2000 decision of the California Supreme Court, it agreed with Agricultural and held that, quote, an insured does not bear a risk of affirmative tort liability for failing to perform the panoply of indefinite but fiduciary-like obligations contained within the concept of insurance bad faith. Such circumstances do not exist in the context of an insured's responsibilities towards its insurer or in the reciprocal context of an insurer's legitimate expectations from its insured. Close quote. To paraphrase what George Orwell opined in his novel Animal Farm, some litigants are more equal than other litigants. Since both the insured and the insurer freely entered into the contract of insurance, it would appear only fair if one is allowed to obtain tort damages for breach of the covenant of good faith and fair dealing. The other should also have the same opportunity. Unfortunately, no court has agreed. While Connecticut, like California, recognizes that every insurance policy carries an implied duty requiring that neither party do anything that will injure the right of the other to receive the benefits of the agreement, no Connecticut court recognized a tort of reverse bad faith against insureds, nor are Connecticut courts likely to do so in light of established precedent. It follows that because of an insured's breach of the covenant is not actionable in tort, an insurer cannot lessen responsibility for its own tortious conduct by putting forth an affirmative defense of bad faith. An insurer can commit the tort and is obliged to pay tort and punitive damages. An insured who is totally evil, whose only interest in the insurance agreement is to defraud the insurer, who refuses to cooperate with the insurer's investigation, who does everything possible to harm the insurer, cannot commit the tort. The decisions rejecting a tort of bad faith against an insured who treats the insurer in such a way as to deprive the insurer of the benefits of the insurance contract is as logical as stating that men cannot commit a battery while women cannot commit the tort of battery, regardless of how viciously the victim is battered. It is a statement that equal protection applies to all citizens of the United States except insurers, since they can only be the tortfeasor and never the victim. Because of the lack of equal protection, plaintiffs' lawyers and their clients take advantage of insurers and use their wits and energies to set up the insurer for a claim of bad faith. In Wade v. Emasco Insurance Company, a 2007 decision of the 10th Circuit, it recognized that the undisputed evidence in the record showed that plaintiff's counsel's sole reason for rejecting the insurer's offer of settlement, made after the running of an arbitrary deadline, was his hope to pursue a bad faith claim against the insurer. As a result, the court refused to allow the plaintiff to pursue the bad faith case. The 10th Circuit also noted that although the impetus for insurance bad faith claims derives from the idea that the insured must be treated fairly and his legitimate interests protected. It is designed as a shield for insureds, not a sword. Courts should not permit bad faith in the insurance milieu to become a game of cat and mouse between claimants and insurer, letting claimants induce damages that they then seek to recover while relegating the insured to the sidelines as if only a mildly curious spectator. Specifically echoing arguments made in several law review articles, insurers and commentators like me complain that without reverse bad faith, insureds can take a no-risk gamble by seeking punitive damages while their insurers, and by extension shareholders and policyholders, bear the burden of the high investigation and defense costs associated with those claims. The strongest argument for recognizing a reverse bad faith cause of action can be made where the insured commits fraud when making a claim under a first-party policy. In an article by Victor E. Schwartz called Common Sense Construction of Unfair Claim Settlement Statutes, Restoring the Good Faith in Bad Faith, it critiqued the arguments against reverse bad faith and commented that the lack of case law to support it is strikingly reminiscent of the language of bad faith law only decades ago. In the most succinct of the explanations from these cases, the Ohio Supreme Court refused to recognize a claim for reverse bad faith where the insured made a fraudulent claim and then sued in tort, alleging bad faith in the refusal to pay. The court in Tokels and Son versus Midwestern Indemnity, a 1992 case, explained, quote, "This court has never recognized such a tort and refuses to do so now. As the holder of the purse strings, the insurer has a certain built-in protection from such evils. On the other hand, the insured, who often finds himself in dire financial straits after the loss, must have the equal footing which is provided by the ability to sue the insurer for bad faith. There are other avenues for the insurer to pursue in the event that an insured submits a fraudulent claim. An insurer drafts the policy, can refuse the insured's claim, and could assert a cause of action against the insured for common law fraud." Close quote. Logically, as applied before commonality, insureds who were wronged by their insurers limited their recovery to contract damages. They should be compelled to waive the tort and sue in assumpsit, the common law name for breach of contract. If the tort of bad faith must exist, it must be applied, in my humble opinion, equally. The abuse of the tort of bad faith has become so extreme that the tort must be eliminated, since the weight of authority is that no matter how reasonable are the arguments to do away with the tort of bad faith, the tort must be applied fairly and equally to both insureds and insurers, and if that is impossible, the tort of bad faith is contrary to the requirements of the 14th Amendment to the U.S. Constitution and its requirement for equal protection. An insurer who is wronged by its insured should have the same right to tort damages and punitive damages for breach of the covenant as can the insurer suffer from the claims of the insured. No litigant should ever be more equal than another. This video was adapted from my book, It's Time to Abolish the Tort of Bad Faith, which is available from Amazon.com as both a Kindle book and a paperback, and is a supplement to my treatise, Zalma on Insurance Claims, in 10 volumes, which are also available as Kindle books and paperbacks. If you found this video to be useful or of interest to you or your friends, If you viewed it on Rumble, please click on the Rumble button. If you viewed it on YouTube, please click on the like button. And please refer the videos to your friends and colleagues. Thank you for your attention.